Okay. Good afternoon, everyone, and here in the audience at DePaul, welcome and thank you very much for being here. As you know, I've, like all of you, am committed to our practice and our profession and continuing legal education and the quality and raising the quality of service that we give to the community that we serve in our state and others, as well as promoting civility and goodwill among us. I hope that this is a timely program, the ethics of client communications, and I think it's timely, and it's a step in the direction of better lawyering for the community. For the next 2 hours, our esteemed panel will take you through hypotheticals, some analysis, and some study that will provide you a better understanding of communicating with your clients. Justice Maureen Connors of the Illinois Appellate Court of the 1st District is joining us. She has spoken on this subject and is very committed to educating lawyers and judges. Jim Grogan, the Deputy Director and Chief Counsel of the Illinois Attorney Registration and Disciplinary Commission, is with us today. That's the ARDC of the Illinois Supreme Court, and he is kindly giving of his time and talent and energy as well. Jim has taught legal ethics at DePaul Law School and Loyola Law School as an adjunct professor. Our third panelist is Dr. Sara Parikh, Managing Director at Shapiro Associates. Sara received her PhD in sociology from the University of Illinois, Chicago, where she studied consumer and professional behavior. Thank you all very, very much for you being here, our panelists. As you can see from the materials, they've put considerable effort into having us prepared for today. So to learn more about this topic, the materials that are provided in the handouts you've received both here in the room and for the several thousand of you that are on the internet, there's those materials, including an article that I wrote for the Chicago Lawyer in this month's issue. This seminar is being taped, and the 2-hour program and the materials will be available for viewing, not for CLE credit though, later on my firm's website. So for those of you who, I have friends who sent me emails and said they couldn't attend today, but can they see the program, and they can go to our website, cliffordlaw.com. I'd also like to mention, too, a past panelist for us in these seminars, Professor Steve Salzberg of George Washington University. He's also been a publisher of a new book, Trying Cases to Win. And in this, it covers criminal and civil trial work. In particular, Chapter 13 on witness preparation and delivery is pertinent to the topic of client communications. So please see your materials. If you'd like to order this, I got you a discount, 25% off. If you go in with the promotional code Clifford14, you'll get a deal. You'll save $30. Okay? So without further ado, I'd like to begin our program, and your questions, by the way, to the panelists are welcome throughout the program for everyone in the room and on the web. They'll be read to us when we can field and sift through them. And I want to thank everyone for joining us today through the magic of technology. We have 3,600 people registered for the program, so we're very excited about that. So let me turn the program over to Jim Grogan. Jim? Thank you for being here, sir.
Thank you, Bob. And you know, I was a little frightened when I was asked to do this, because I said, come on, communication, how dull is this going to be? Please don't make me do this. But Bob said, you're doing it. And then I said, okay. So here I am. But I want to tell you, when I was preparing for this, I started looking through some ABA journals, and I happened across a fascinating article called Lawyers Must Be Effective Communicators. And I said, well, that seems to be on topic, so let me see what I can crib from here. And the author writes, much attention has recently been focused on the inability of many college students, including law students, to write correct, effective English and to, in addition, deliver appropriate speeches and communication. I'm looking at this, I'm saying, wow, that's really timely. And I looked at the date of the article, June 1961. And if they're having problems in 1961 with communication, where are we at today? But there's one sentence in this article I thought was interesting, and the sentence read, many potentially successful careers never materialize because of faulty communication. And to that I would say, many careers falter because of unsuccessful communication. I think we're going to be dealing with a lot of examples of faltering and poor communication. And I know the focus is largely on good attorney-client communications, but a lawyer's communication isn't limited to dealing with clients. Let's face it, we have to survive. So it's prospective clients, it's judges, it's colleagues, it's the world, it's the media. So, these are really important topics. A couple of numbers. First, lawyer regulation, because I'm a lawyer regulator. The last time that the ARDC reported numbers, there were about 6,400 grievances filed against what we now have is about 94,000 lawyers in the state of Illinois. So we have about 6,400. And if you break down the numbers, what you see is, and this is historically every year, number one will be failure to communicate. Number two will be neglect. Or number one will be neglect. Number two will be failure to communicate. You lump them together each and every year, not just in Illinois, around the country. Anywhere between 55 and 70% of client grievances are generated because the client believes there's a problem with communication, which is really strange when you think about it, because the U.S. Supreme Court says that we as lawyers are far better than accountants. I mean, literally, they went on record. We're not accountants. Why? Because we're trained in the persuasive skills. We have skills and abilities that common folks don't have. And in theory, we're trained to be communicators, but a lot of times we fail. So we have a lot of grievances. That's in the lawyer regulatory arena. I'd like to talk for a second about the legal malpractice arena, because for most people in this room, when it comes to communication, it's not the ARDC, it's not your bar association where you have worries, it's going to be your malpractice concerns. According to a number of studies, and this affects the sole proprietor, the small firm practitioner, and the big firm lawyer, there's 4 areas commonly the subject of malpractice filings. And in reverse order, 4, failure to catch errors in work delegated to assistants. You can see that if you're in practice. 3rd, poor investigations that miss basic facts. Another thing you can really see. 2nd, missed deadlines through bad calendaring or failure to even know of the appropriate deadline. Again, you can see it. But the number one area for the filing of malpractice claims, poor communication between lawyer and client, resulting in disparate understandings of their arrangements. So there it goes. For malpractice purposes, for regulatory purposes, it comes right down to communication. And I've got to say this because I was trained by Jesuits, so the Latin root of the word, sorry, Bob, is to impart. It means to impart. And I think that's what we're going to be delving into today, how people impart information.
Well, there you go. Well, speaking of imparting information, permit me to introduce and turn this over to Dr. Sara. By way of background, Dr. Sara Parikh is one of the foremost jury consultants that I've ever worked with. In fact, I don't think I've gone to verdict on a big case in the last 20 years where she wasn't right beside me, helping me put it all together. And we've actually studied this issue of communications for a long time and the perception of lawyers for a long time. Going back to when I was chair of the ABA section of litigation, we did some work on public perception of lawyers. So, Sara, tell us how we can talk about communications and learn from some things from you.
Yeah, so I'm going to really talk here about sort of come more from the client perspective than from an ethical perspective. You know, what are the sort of best practices in client communications, and what have we learned from some of the research that we've done. We've done work with Bob, as he mentioned, since about 2002. I think we did some work in that on client satisfaction with their lawyers. So today, I just want to kind of reiterate something that Jim just was talking about, and this is the ARDC filing. So if you look here, I've got a nice little chart to sort of represent his numbers. So if you look at grievances to the ARDC in 2012, 38% of them pertain to client neglect, which is essentially a lack of communication, and then another 20% pertain to failure to communicate. So that's the primary reason why people are dissatisfied with their lawyers. And you'll see that not just with individual clients, but also with corporate clients. I mean, corporate clients talk a lot about either failure to communicate, lack of responsiveness, lack of proactiveness, those kinds of issues. So they're not focusing on the outcome necessarily. You'd be surprised. You'd expect them to be focusing on the outcome of the case. It's more about the process of the case. And when we try to unpack what it is that they're looking for, there's some really basic, simple, this is not rocket science kind of stuff. So we'll go through some of that as well. And I mean, the good news is, if you can go back to the last slide, Sean, even though we're talking about kind of the negative, the dark side of client communication, and really most of it's just a lack of improper communication, most clients are satisfied with their lawyers. So we talked to, last fall we interviewed about, 400 or 500 consumers across the country to find out who's hired a lawyer in the past 3 years. And among those that have, you'll see pretty high satisfaction rates. So most lawyers are doing a pretty good job in terms of keeping their clients informed.
Isn't it what we found in some of the early work that there might be maybe a dissatisfaction with the legal profession, but lawyers are capable of developing a relationship with their clients that is satisfactory to the clients?
That's exactly true. I mean, people are more satisfied with their own lawyers than they are with the profession. I mean, considerably more. And that's kind of similar to Congress, right? We're more satisfied with our own personal congressman than we are with Congress in general. So you see that kind of, the closer you are, the closer your relationship. You certainly can overcome the bad reputation the profession might have. But to Bob's point, I mean, when people are thinking about hiring a lawyer, there's a real ambivalence because they don't really know. It's like hiring a general contractor. It's a big black box for them. This is your sophisticated business clients know what working with a lawyer is like. But when you're dealing with consumers, there's a lot of unknowns. And so really trying to unpack that, they feel like they have to give up a lot of control to this person that they don't even know. So there's a lot of tension at the very front of the relationship, and a lot of, I would say, suspicion at the very beginning of the relationship. And so, by communicating, by kind of respecting that and understanding that you're coming in kind of at a disadvantage at the beginning of the relationship, you'll have to overcome that through regular communication, through being upfront and transparent, and so forth.
In your studies, had there been any conclusions that you were able to draw about what the core problems are in terms of the communication?
Yeah, I think the next slide. So here we're talking about, as I mentioned before, it's more about the process than the outcome. And a lot of it is centered on just basic keeping the client informed of the progress of their case. And it doesn't always have to be proactive. I mean, it's really, you can even be reactive. You can just respond to an email or a phone call. It's amazing how much of that is they just didn't call me back in time, or they never called me back, or I've sent 4 email messages and I've never heard back from anybody at the firm. So part of that is just basic keeping them informed. And then the other thing is transparency. They don't like surprises. So even if you can say up front, I don't know exactly how much it's going to cost you, but I can give you a range, those kinds of things. They don't like surprises at the end of the case that they weren't expecting. So just really, really basic things. The other thing you'll notice about this slide is when we ask them how satisfied were they with different stages and different types of communication, you'll see that lawyers are doing a better job at the upfront communication. So a better job at telling them, what to expect, setting expectations, fee transparency, than they are during the progress of the case. So that's where the weakness is. It's, keeping them informed, kind of having some sort of system or study system for keeping clients informed in the case.
Justice Connors, at this juncture, Sarah, I didn't mean to interrupt.
Yeah,
Are
that's
you done?
okay.
Okay.
No, let me quickly, I'll go through these really quickly because I know we have a lot to cover. This one I just wanted to mention because this is really important. One of the things we asked this last group of respondents is, how did you find the lawyer? And you'll see most clients are finding their lawyers through word of mouth. I mean, that's pretty classic, through referrals. But what they're also doing now, which is very new, is half of them are looking up their lawyer online before they decide to hire them. So your online presence, whether you control it or not, is important to acquiring clients and your reputation in the community.
And I saw that you had a line on here for the yellow pages. I don't even think they have yellow pages. But you know, true to that, I think you know, a lot of lawyers will talk about the fact that their websites are not only a tool to be found, but once found, we find an incredible number of people who visit it. You know, like you're saying, 48%, 46% who visit the website for further information about the lawyer before they even want to pick up the phone.
That's right.
Yeah.
And they'll also look at Yelp reviews. If you look at the next slide, we just did an analysis of the positive Yelp reviews for what were considered by Yelp the best lawyers in Chicago. It's all about process and communications. All of the reviews are about, they're responding to my inquiries, they're providing thorough explanations. It's not about the outcome of my case. So that kind of just goes back to this idea of communications.
So the lawyer who's out there saying, I don't really have to communicate with the client because I get the client's great results, he's kind of missing the boat.
He's missing the point.
Okay.
Yeah, because part of the great result is the whole process.
Okay, Justice, what's the view from the bench on this?
Well, one point I want to make, just to let you know, I'm lucky enough to be able to teach judicial ethics to judges, new judges when they come on at new judges school. And I advise those judges to avoid social media at all costs. Facebook, LinkedIn, and they're all, I want to see my grandkids' pictures. Whatever, send it to them. I think judges should avoid that because there is no expectation of privacy, none whatsoever. Anything that goes on Facebook, LinkedIn, and I know I'm not calling those people out, YouTube, it's all over the world. When we were in law school, it's like, God forbid anything you do that's bad is on the front page of the Tribune. Forget about the Tribune, and now it's going to be all over the world. So I counsel my judges, stay off. You do not have that luxury. You probably need to be on these social sites. And what do you do with that? How do you handle that? How do you handle it with your clients? I think, are you supposed to tell your clients when you're in litigation, maybe you should proceed with caution, my dear client, when you're going through your divorce? Let's not put silly things on social media. Or should you remind your clients, maybe you should not clean up or delete a social media site that you had because we might be subject to spoliation claim or sanctions under 219. So you have a responsibility as well to your clients to tell them about these social media issues. The other thing I want to mention real quick is email. Email, what's the right of privacy or what expectation do we have to privacy in email? Email's been compared to a phone call. Well, it's kind of like a phone call, but then again, there's a document that's produced at the end of an email. That's a lot different than a phone call. It's also been compared to a postcard. When you send a postcard through the mail, everybody's going to see it, and maybe that's what email is like as well. So states have different expectations of privacy as far as email is concerned. So if you're dealing with clients outside of Illinois, you better know what that expectation is of privacy on that email if you're dealing with someone out of state. God bless you with social media. Mr. Clifford.
Wow. I'd like to go back to one of, Sarah, one of your slides on best practices in client communication. And I'm curious about why you listed the things that you did, but then I'd be curious about Jim Grogan's reaction to where he sees the absence of these best practices yield results that end up at our ARDC. So, Sarah, what are some of the best practices that you think?
Yeah, and there's some of the things that I touched on already. Establishing expectations up front. This is what you expect. I mean, you know the process. They oftentimes don't know the process. So establishing those expectations up front, even setting expectations for timing and frequency of communication. So you don't always have to be talking to them once a week. If you say, I'll call you once a month. If you don't hear from me, it's okay. But then respond if they do reach out to you. I mean, a lot of this is about being responsive rather than being proactive, especially during the process of the case. And then, but if there is a problem, if you sense a problem, or if they communicate some sort of dissatisfaction with another lawyer in the firm or with yourself, get out in front of the matter. Because the best way to keep your reputation is by avoiding negative Yelp reviews or negative, blog reviews, those kinds of things.
We saw a couple, in the materials, there are a couple of positive Yelp things and negative Yelp things. Tell us about those. Where'd you get those from?
From Yelp. Just went, just went to Yelp.
And they were about lawyers from...
So if you look at some of the positive ones, and this just kind of goes back to what I was saying, these are what Yelp has defined as the best lawyers in Chicago just based on their ratings, right? And so we did a little search for the ratings around these best lawyers and what are they saying about them. It's all about clarity of communications, and it's all about responsiveness. Not he reached out to me, but he responded to my phone calls. She, answered my emails like right away. Those kinds of things. So clarity and responsiveness, and even if you can set up some sort of process, especially if you've got a bigger firm, even if it's just some general guidelines. I mean, you can't always respond right away if you're in court or you're busy with other practices. But some sort of general guidelines, try to respond within 24 hours, even if it's just I can't get back to you right now, but I'll call you this week, later this week, those kinds of things.
Right. I know that one of the best practices you believe in is that if a lawyer's on trial or in court, but has a legal assistant that is proactive in reaching out to the client to say, we're on it, we'll get back to you, that kind of thing?
Yeah, I mean, it doesn't have to be the lawyer. It can even just be you assign somebody to make sure that they know that you haven't forgotten or that you're not ignoring them. So, having some systems in place.
In those complaints that you do get at the ARDC that deal with communications, do they focus on these things that Sarah's talking about?
Yeah, we didn't talk about this before this moment, but I have a friend who's a family law practitioner. And in his contract, he says, look, if you reach out to us within 24 hours, someone from my office will contact you. And when he meets with the clients, he says, it may not be me. I may be on trial. But it'll be a paralegal, it'll be a secretary, but you'll have the satisfaction of knowing that someone will touch base with you. And what we find out in regulation many times is what the client's calling for is, I have a new email.
Right.
Or I'm going to be out of town this week, and I know you were talking about maybe scheduling something. A lot of the things that we deal with, the lawyer who's very busy sometimes views the client as just one of a group of clients. But the clients have one matter. And for people that aren't well versed in the law, it means everything to them. So sometimes they have unjustified expectations, unrealistic expectations. And good communication at the beginning of the relationship, basically establishing the communication relationship, tends to diminish those concerns.
Right.
We have questions here coming in from 3,500 people on the internet, among them being, what can or should you do about a quote that is completely untrue on Yelp or Avo or these other...
We're going to get to that. Let's turn to the negative ones. So I didn't like my experience with this lawyer, but figured it may have been a fluke. After checking, I found a reprimand in 97, suspension in 03, suspension in 09. I guess it wasn't a fluke. But what if that info was wrong? I mean, what remedy do you have?
Well, I mean, the starting point here is they're looking, and everybody's got easy access to stuff online. So, even if you don't have a negative Yelp review, they could be trying to find dirt on you or trying to find, dig down online. So your online reputation, generally speaking, is going to be important for your practice and for your reputation.
Jim, what's your experience been with this?
Yeah, this is a huge issue all around the country, and it's getting bigger because a lot of lawyers say, look, the world is changing, and the way that consumers view hiring a lawyer has changed profoundly. You'll go to Yelp, you'll go to Avo, you'll go to lawyerratings.com. You want to be an informed consumer. And the lawyer says, what if a false, review is posted? What if one of my opposition is filed, or what if the competition's filing these things? How do I defend myself?
Well, I had that experience. I mean, I had two receptionists. They trashed me, and they weren't even clients.
All right, so,
I
the-
called Avo, and they removed it from me.
all right, comment from the floor, for those of you who couldn't hear, a lady in the audience had two receptionists who put some things on Avo, and they were inaccurate, and you complained, and they removed them?
First of all, I didn't think that they should put, they didn't
They
return
weren't
my
even clients,
services.
they were
calling from doctor's
disgruntled
offices.
employees.
No, they were calling from doctor's offices trying to find out what the status of a case was. They wanted their bill paid.
Okay.
And they kept calling, so I got a little impatient with them. And she and her coworker put some horrible things. My 10-year-old niece pointed it out. Is that you? Like, I was like horrified. I didn't even know Avo existed.
And how do you defend yourself?
How
So
do you
I
defend
called
yourself?
Avo. My secretary got the number, and they removed it.
Yeah,
They
and-
actually removed those two, and then my ratings went way up.
Okay.
All right, well, that actually lets us, and your comment about your friend who does family law, leads us into our first hypothetical that maybe, Jim, you could introduce, and it'll help us cover some of this ground.
This is the first of our many difficult named scenarios. This deals with Margaret and Hope. And Hope retains Margaret, who's a family law practitioner, to handle what she says is an uncontested divorce. They're all uncontested.
Of course.
Margaret asked for a $750 fee. Hope was a most difficult and needy client. So I want you to imagine this, because this has never happened in your practice before. So what happens is Hope not only consults about the family law issue, but about employment issues. And the lawyer realizes, why, gosh, this is a needy client. I've got to spend a lot of time with this individual. At some point, she is, the lawyer, able to procure a divorce for the client. At this point, the client has only paid $350. So the client has the decree. And what thereafter happens is the day after the divorce becomes final, client posts a review of lawyer's service on an internet website called rateYourAttorney.com. Hope, using her full name, wrote that Margaret was a big zero as a lawyer. But moreover, she said Margaret never returned phone calls, never showed up to on time to court, seemed to forget all the details that I had told her about, and you know what? Her law office had a certain smell about it and was disheveled and dirty.
And what did Margaret do about it?
Wow, was Margaret upset, Bob? It was a situation where she posted a response. And the response said, let me tell you, I only charged this client $750, and she only paid me $350. And not only that, but she had a boyfriend, and the boyfriend really was manipulating her. And you know what? I spent an awful lot of time with this client who was very needy, talking to her about employment law issues, you know, stuff that I wasn't, you know, it wasn't part of the deal, and I did this. So she basically put this in as a response to lawyerratings.com, and thereafter, Hope files a grievance saying, how dare my lawyer in a public forum that can be Google searched find out about my private life.
And what did the chief prosecutor for the ARDC say about that?
Oh, no. But this goes to what your point was. I mean, I think a lot of lawyers are experiencing this. And a lot of people are saying, what do I do in this situation?
And isn't that, though, a real problem, because the lawyer's obligation pertaining to maintaining client confidences, privileged communication, there's got to be a contest there. There's
Well, in the new rules that have just come out, you have to get what's called informed consent from your client. You have to get their permission to put any of this out there. So other than her name, I don't know what authority the lawyer had, because she disclosed her full name. Other than that, I don't know. Is all this questionable? Could she be subject to an ARDC complaint because she disclosed all this private information that the client did not informedly consent to?
And Sean Davids just posted what the justice is talking about. It's the general rule. And it has changed a little bit over the course of our career. And And 1.6 now basically says, you have an obligation as a lawyer to protect information. And what's information? It's everything you acquire during the course of the relationship with your client. One subset of that is privileged information, so the communications of what I talk to my client, but it's broader than that. It's everything.
So,
So what's the remedy? I mean, hypothetically, you take this situation, would the lawyer possibly post something saying that professional duty and obligation don't let me to file a response, but what she says here is untrue?
I mean, I wouldn't even recommend that.
Why?
Well, because what I would do is take a couple things. One is, I mean, it's helpful to file a response, like they do with retailers when you complain about, slow delivery or something, they might file a response. But the response would be just something very benign, is, I'm very sorry to hear you're unhappy. I will follow up with you by telephone. And not only for the client's sake, but I think for all your prospective clients, that's the most respectful thing to do. And it says, I'm not going to get defensive here. I'm going to stay above the fray. So I would do something benign. But even, like in her experience with was it Avo, you said? Avo. Yeah, I mean, some of these websites will actually take these down. So, I mean, if you have an option, if you can reach these ratings websites, and if you've got a legitimate reason to say this is not a legitimate complaint, you might be able to get it taken down. But I would do the most benign thing and then not engage with them online.
But isn't there, like, being the devil's advocate here on this, if there's such a complaint and it's really baseless and if you deal with matrimonial law, family law, you're dealing with emotionally charged people. You deal in the tort arena, emotionally charged people. Probate, same thing. And when, in our world, the internet, you talked about earlier about the internet and the growing importance of it, and people go to search about you, isn't this adverse stuff going to pop up? And when it pops up, I mean, wouldn't you be better off having something out there? Okay, sorry that you feel this way. We both know there's another side of the story, or it's incorrect. I'm not sure what the exact, I mean, that's what we're here to get your advice about. Judge, what do you think?
Yeah,
well, I agree with both of you. I think a combination of that response would be perfect, because you could say, due to my professional responsibility, I cannot disclose, but if there was a problem, let's talk about it. I think the combination of both, putting the professional first, you're a lawyer, you have certain rules you have to live by, and then putting the personal.
A little bit
I'm
of
so,
customer
this is that,
service.
and right, to assuage the person. So I think the combination would be very effective.
We have a comment here, though, from Sam online that says, why hasn't the client waived the attorney-client privilege? Can you put a waiver in your retainer agreement?
Hot thickens here. What do you think about that, Mr. Grogan?
Thinking like a lawyer. Are they independently represented during the course of, I'll tell you, with a lot of these things, could you put on slide 34, Sean David? We know when there's a rule,
Page
there's
34.
sometimes exceptions. So it's slide 34.
All right, there you go.
One of the exceptions is what you're going to, or with our person out in the internet's talking about, is essentially subsection 5, okay, which is the self-defense rule. It allows the revelation of certain information in a certain context. And it basically says to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. Essentially, the lawyer can reveal to the extent necessary. Otherwise, you couldn't collect a fee.
Right.
If you weren't allowed to be able, some limited ability to talk about things. But I'll tell you, this self-defense exception really hasn't been adjudicated to any fairly well. And where it has been adjudicated, most courts are saying, look, that's in a malpractice case where client has sued you. You have to be able to defend yourself this way. There are very few jurisdictions that have said where a client criticizes you, it's an exception to the rule.
Right.
And
Right.
Don't you think the
Justice?
attorney-client privilege is such a protected thing, and it's their privilege? How could we possibly put it in the contracts that, well, I'll be your lawyer, but you're going to have to sign this waiver of attorney-client privilege? That's just not going to happen.
Can I say something? Okay. So I think these rules, like anything else, maybe should be modified in light of, technology, the internet. So I mean, I think that if, I know what I started doing was I started asking real clients to stop posting positive comments if they felt that they liked my representation. So when they post the negative comments, that can affect your livelihood, because somebody can go on the site and say, well, I'm not going to hire this lawyer, and believe some nut job. And you can't do anything to defend yourself just by saying, sorry you feel that way. I think we should have more. I think the clients have too much power.
Well, they do have power, and that's the power of social media, but I think Dr. Parikh would tell us that the best strategy is to find a way to diffuse this and not get a banter or a badminton ball going back and forth, because the lawyer can't possibly win in that situation.
That's the thing. There's no winning from, once they post a bad review, and if you engage with them in a defensive or a discussion online, there's no winning. There's no winning new clients. There's really just no winning for the lawyers. So you get it offline as soon as you can. That would be my recommendation.
Colleen is asking online, that even if you contact Yelp about any negative or false reviews, wouldn't you have to be revealing confidential or private information about the client to Yelp?
Not if you ask Yelp to take it off. I mean, you wouldn't be.
Yeah, and maybe if you follow 1.6 parent 5 as closely as Jim was just suggesting. And frankly, I'll tell you what, in today's day and age, I would certainly encourage people to get advice of counsel. If you're going to do some of these things, there are plenty of lawyers out there who are specializing in ethics. There are law profs all over the place who are available for consultation. Get some advice so that if this thing does end up at the ARDC, you've got a record about how you've done your due diligence and professionalism.
And to point out, back on slide 34, there is subsection 4 that says, look, when you need advice from somebody, you can go to a lawyer, because that's privileged.
Right.
Bob, help me through this. I've got this problem with this client. I don't know how to best address it. Do you even want to address it publicly? And if you do address it, you got to worry about Rule 1.6. Now, you didn't have 1.6, the questioner in the room here, you didn't have a 1.6 concern in that situation, because these are secretaries reaching out. So it's not, it's a different scenario, and they said, oh yeah, it's not the client, so let's pull it down. I've heard a lot of commentators suggest that, yeah, you can ask clients who have favorable reviews and post those. Or you can have a very professional response saying, look, I can't respond. The professional rules don't allow me to, but I manage my career in a very professional way. Boom. Which begs the question, what happens if you get the idea that I'll post my own good reviews of me and pretend to be a client? I mean, come on Yelp. I've gone to some real garbage restaurants, right? And they're glowing reviews. So what about that?
Shouldn't lawyers be truthful at all times? Now, please.
There we go. On that note, we do have one question from the floor. Mr. Griffin?
The only point I wanted to make is, this new rule on disclosure is so broad that it comes up in a lot of benign situations. I mean, if Justice Connors writes an opinion and I get a call from the law bull and they want to talk about the case, I feel now I have to go to my client and say, can I confer about the case? Can I say something in public? Because it used to be that the rule, was written in a way that you had to protect information that the client would expect to be private. But the literal language now is, it's any information, whether it's even put in the public domain or not. So it comes up in a lot more benign situations than these.
Thank you. Justice Connor, could you introduce us into the second hypothetical? Talk
Well,
about
I would like to,
Finbar
but I
here.
think Dr. Parikh wants to.
Did I get that
Yeah,
wrong? Well, you're right, I'm sorry.
I'm
Sarah.
Finbar and Finula.
Can I just interrupt and
Yeah.
say what that first problem was a real case?
Yeah, okay, the first problem was a real case
From Georgia.
from Georgia. And what happened in Georgia?
Yeah, what happened?
And the case proceeded to the state bar, and the state bar said, you're not a bad person. Why don't we agree to just a reprimand? They filed a petition in the Georgia Supreme Court saying, yeah, she violated 1.6, but she's otherwise a nice person. The Supreme Court of Georgia said, no. Usually when you're talking revelation of client secrets, suspension is an appropriate sanction. The case has been retried. It is now back before the Georgia Supreme Court. A hearing officer has recommended the lowest sanction possible, saying it should be a reprimand. So Keep reading.
I will say, Joan was asking, what about when an adverse party posts untrue comments about you, about a lawyer, and that you're in litigation with?
Adverse party or adverse attorney? Again, I don't know that any of the things that we've said as strategies would change. I mean, if they're untrue, there's some issues there possibly of defamation. If they, you've got cases there, Jim.
You hate to say this, but these rules are dynamic. You just don't take one. If you're talking about pending litigation for the questionnaire and the internet, you've got slide 37. If you've got pending litigation and you're talking about pending litigation, are you going a little bit beyond by what you say? Has your opponent done so? Because you're dealing with trial publicity in those instances. So I just say that, there are a number of rules that could be relevant in this discussion.
And it may well be, and again, that's why I go back to my thing about seeking a relationship with some ethics counsel, because possibly that lawyer's remedy is to file his or her own complaint with the ARDC for an opponent posting untrue statements about a lawyer. That's certainly something that can be done. Sarah, tell us about Finbar and Fanula.
And Fanula.
Where did these names come from? I think they came
right
from
here.
Jim.
Finbar and Fanula. So Finbar Joyce is a criminal defense lawyer who represents people charged with felonies. He has a website that markets his experience and abilities, and he also writes a weekly blog called Finbar's News from 26th Street that he publishes on his website. Each blog entry describes a case where he represented a criminal defendant. So Finbar published a blog post without his client's prior knowledge or consent, which read, "Late one evening, Fanula O'Brien was in a West Side hotel room with 3 men." I love this story. Police officers, relying on a tip that one of the men was a wanted felon, entered the room and conducted a search. The search uncovered 3 smoking devices that appeared to contain cocaine residue. All 4 were arrested. Now, Fanula maintained that none of the items were hers. Police, though, obtained a warrant to draw her blood and found that she tested positive for cocaine. So she was charged. On August 1st, 2013, she was found not guilty of cocaine possession, and in a case argued by Finbar Joyce, Circuit Judge McGoohan found there was insufficient evidence that Ms. O'Brien possessed cocaine. Now, all the information, the story here, the important thing here is that all the information was in the blog that Finbar posted on his website. But all the information in the blog could be found in her criminal court record. And anyway, so Fanula later found out about this and filed an ARDC grievance.
And is this too a real case, Jim? It is.
Yes.
Not the real names, though, I think.
Not the real name.
Definitely not.
So, and what did the ARDC do about this one?
Well, we didn't do anything about this one.
Okay, where'd this come from?
This came from Virginia.
Virginia. There we go.
This was Virginia.
Judge, what's your reaction to this one?
Well, it seems very similar to the last case, that the lawyer is giving out information that was private to the client. What trumps what? Informed consent or the freedom of access of these files to the public? And are these files totally public files, criminal files? The blood test, what the results were? I don't know. Can anybody go into 26 in California, grab any file? Give me the file for Fanula O'Brien. Is that truly public access? I don't know. I kind of doubt it. So I think this lawyer gave up a lot of private information that was well beyond and should have gotten the consent from the client before it was done.
Jim, what do you think?
Well, there's a tension here because it isn't a public record. A reporter could come and look at it. So they say,
Leonard, this is just what I was talking about, yeah. Under the new rule of ours.
But let the reporter do it, not the lawyer. And what if she had asked to have her files sealed, or she tried to get a record expunged? All of a sudden, this is information that's going to be public now that she had expunged or she had sealed for some reason. So there's another problem you have.
But what about the lawyer's First Amendment right? I mean, isn't there a truth as a defense here? Going back to what was asked about earlier, it was, all these things were true. Her blood did test positive for cocaine, that's in the file. She was charged with a crime, but she was exonerated. So what's the problem? You know, I mean, these go to like these websites now where I recently had a friend was pinched for a DUI in Florida. And, you know, she's a pretty lady, but at 2 o'clock in the morning, half in the bag, her mugshot doesn't really look very nice. But, so they post this thing, but for a fee, for a couple grand, they'll take your picture down.
Now,
How about
that's
that?
wrong. That's wrong.
Well,
Some people
but-
with money get that benefit, but others do not.
How about that?
There's a class action.
There we go. A question from the floor, Leslie Rosen.
Anyone can walk into the Daily Center and pull a file. They're all, so,
Right.
and I would imagine the 26th in Cal is similar, but even if it's not, it could be a tort case. It could be anything that involved a blood alcohol level that's totally public information.
Of course,
So-
but the relationship between the lawyer and client is different between some citizen who comes in and pulls that file. That's
I
what's wrong.
don't think you're disclosing personal information. Who am I?
Great minds differ.
Thank you.
You know what just flashed in my mind here? So we have one of, you know, the city's premier appellate lawyers picking with a fight with a sitting appellate judge. That's, I don't know about that one. I would have counseled you otherwise about that. But who am I? Okay.
I'm agreeing. That's why the new Illinois rule is written so broadly that it really, I think it covers publicly available information. Now, maybe it wasn't intended that way, but that's the way literally it reads.
Well, we need a test case, so why
You know,
don't? yeah.
and you raise a good point. One thing is Illinois now is one of most jurisdictions that have adopted this verbatim. So there are most states, most territories are in the same bag with this issue.
So the worst or most restrictive interpretation of this is what? That the lawyer could never post this on his blog at all?
Well, not the details that this lawyer went into, I think. The fact that she was arrested and charged with whatever, that's pretty much public record. But all the details about all the rest of it, I think might be too personal.
Okay.
Speaking of judges, we have a question from Janice on the internet here that says, should a trial attorney assume that the judge has Googled clients and witnesses? Is it appropriate for a judge to Google parties without disclosing it at the trial?
Great question.
Ah, that's a lovely question. I don't usually Google people. We're very busy. I'm not spending time Googling people, but why don't you ask the question to the court then when you go in? Judge, just wondering.
Justice, I think it's, I'm not telling anything out of school, it's public record. Justice Posner Googles all
Well,
the time.
he's in the
He does
federal
original
court.
research, and you'll read it in his opinions. So there you go. There was another question from the floor. Okay, we got a couple on the right, the microphone.
Yeah, I want to go back to the previous discussion. There is a vast difference between something that you can dig out of a file and the wide dissemination that occurs when you put something in a Google searchable blog.
Yeah.
Okay.
Yeah.
Point well taken. Point well taken. Yes, sir.
Brian is asking about hypothetical two here. What if the real names and specific dates were not given? Would that change your answer?
Quite possibly, I don't know. I mean, if he said, I had a case up yesterday and her name was Susie Smith, and it was really this other one, I mean, it depends on the circumstances.
It's fact specific, but I think that would make a change. Question in the back here.
Thank you. Isn't there another issue buried within this? As the justice said, perhaps it should be left to a reporter to dig out the facts and not the lawyer. So the lawyer is actually acting as a journalist here, isn't he, when he's blogging? And so the question buried there is whether or not a lawyer should be blogging about anything other than the general state of the law. Should he actually, he's wearing a journalist hat and a lawyer hat, and they're bumping up against each other.
Yeah.
So what do you think about that? Should they be doing that sort of thing?
It's a slippery slope. I mean, you're the lawyer, you have confidences about your client, and you're able to disclose them to the public, to the world. I don't know that that's such a good idea.
You raise a really neat point, though, because
Yeah.
what is the nature of blogging? Is it journalism, or is it marketing, or is it a blend of the two? And you know what? States are wrestling with that issue right now, because a lot of lawyers and their websites have a blog. They're not prohibited from doing so.
Well, you know, one of the reasons why you had the blog go, and it goes to that gentleman's point in the back on the right there about Google. It's how you are found on Google Analytics and all of that, and that's one of the reasons for these blogs. But these blogs can, you know, be problematic if you're not careful about the ethics.
And can I mention the judge thing too? Because I think
Yes.
that's fascinating, a judge Googling things. Because Illinois did not adopt the ABA model code, judicial code provision that explicitly deals with that. In theory, a judge is allowed to go to the internet to seek what is appropriate for judicial notice,
Yes.
but not facts that should have been introduced into evidence by one of the advocates.
Right.
And if it isn't there, you should stay away from it. So we're seeing cases develop, judicial disciplinary cases, where judges were trying to get to factual resolutions of matters, and that's going across lines.
Joseph here asked, what about the plaintiff's lawyer that uses his blog or her blog on the website to publish their side of the information obtained during discovery? Is this ethical, or does it taint the jury pool?
Oh, my goodness.
I mean, I sure hope that's not one of my lawyers, but, you know, I mean, look, I mean, we do our best, you know, an active hot file, you should stay away from talking about active hot files. I think that's,
What would you do if your opponent did that, Bob?
if my opponent did it, I might bring it to the court for a sanction. I might make a motion to disqualify. I'd write a letter to you. I'm serious about that. You know,
Absolutely.
they're prejudicing my client. I've got a duty on behalf of my client to protect my client's interest. And you know, but I tell you, the first thing I do nowadays, we have a guy in our office. He's Bob Sheridan. He's a counsel to our firm. He's an ethics expert, and he'd be the first person I'd go to about this. I mean, we'd analyze the rules.
You can get a
Judge?
protective order to prohibit any of that in the future and figure out if there's a sanction. Yeah.
Well, you know, and the other thing too, because I actually did this once, where if it was a lawyer from out of state, I'd move to revoke his pro hac vici. So, all right. Well, come on, this is not a business for the faint of heart. All right, here we go. All right, how about, okay, time for one more question. We'll get to our next hypothetical.
Along those lines, and I may be a little outdated, I haven't checked it, but don't some states have prohibitions that attorneys can't say things which are going to materially, essentially prejudice the case?
I think every state
I
has.
think that's
Almost
inherent.
every state is what's on slide 37.
Right.
Almost every
That's
state has
37 in your materials. Okay? All right.
Tell what happened in real life?
Yes,
Oh, yeah.
please. Yeah,
Okay, because it was Virginia.
it was Virginia
Almost
again.
exact same facts. And there were a couple of clients, not just this one, but the client basically did a Google search of herself and found this. And it was all in a public record. It was all in a court file. And the Virginia bar said, you violated 1-6 because we agree with Mr. Griffin's analysis of what this rule is. It's you know, very broad. And it was tried before a judicial panel. They have judges in Virginia that hear their disciplinary cases. And last year, the Virginia Supreme Court said the lawyer has a First Amendment right to speak on issues in a public forum.
Really?
There you go.
Wow.
I would not try to be a test case in another jurisdiction.
That's interesting.
Justice Connors, could you tell us about hypothetical number 3?
I would love to. It's about Bill and Bob. And Bill represents a state trooper injured in an accident while serving on duty. The trooper was traveling in his squad car at 125 miles per hour on an interstate while talking on the phone with a girlfriend on a cell phone. He lost control of the vehicle, crossed a median strip, and hit an oncoming car, killing 2 teenage sisters. The trooper later pled guilty to 2 counts of reckless homicide and was given probation. He, the trooper, hired Bill to secure a workers' comp award. Bill is our lawyer. An industrial commission arbitrator, Bob Boyd, was appointed to oversee the action. Bill and Bob, as luck would have it, are law school pals, play on the same softball team. I would hope 16-inch and not 12, because that's
Yeah, it's
sissy
Chicago.
stuff, yeah. Are Facebook friends and socialize on a regular basis. At some point during the pendency of the case, lawyers for the state, seeking to bar any compensation award for the trooper, communicated via email, no right to privacy there, with all parties of record, and Bob, who's our hearing officer, about a substantive issue in the case. Thereafter, Bob replied to the email, but only to Bill, his friend the lawyer, and no other lawyer of record. Bob wrote, "Seriously? I cannot believe that they are bringing this on themselves." Bill responds to Bob, the arbitrator, "I think so too. The defense appears to be that he was acting so recklessly that it takes it out of arising out of. But by that argument, any goofus who pulls the guard off a machine and gets his hand chopped off is out of workers' comp as well. I don't get it." Bob replies, "It's got to be the adjuster calling the shots. It will likely go up on appeal." Great. Whatever. Perhaps the state should have thought about that before they threw 2 young attorneys to be slaughtered like lambs here. Oh my goodness.
So what's the rub?
Well, there's so many problems with this. I love this case. I have notes aplenty all over it.
I know, I saw your notes before.
Oh, my God.
Let's list them.
First of all, let's talk about Bob Boyd. Now, Bob, I know when I talk to my judges, my new judges every year, we talk about when somebody's your friend and you play golf with them every week and you're the godfather of so-and-so and you see them all the time and they're out of their chambers and they appear in front of you. How does that look to the other guy? For our standards, it's the appearance of impropriety. If there's any look of impropriety for the judge, you've got to at least disclose that or you recuse yourself. Now, in this case, Bob Boyd, who technically in Illinois, which I find interesting, we don't require, arbitrators are subject to, of course, the rules for lawyers, but they're not subject to the judicial code, which they should be, because you're kind of a judicial officer here. And any appearance of impropriety that Bob's your friend and you see him all the time, you need to, a minimum, disclose that to the other parties. They have no idea you're Bob's friend. So that should have been disclosed. Number 2, when the state lawyers emailed to all parties of record and Bob, well, that was kind of stupid because you're not supposed to email to the person who's hearing the case. But I would think it was an inadvertent email. So what the hearing officer should have done right away is said, "Oh, this was inadvertent. You shouldn't have sent that to me. I didn't really remember any of it. I'm still fairest man in all the land," and gotten rid of it. But no, he doesn't do that. The only one he responds to is his buddy. Talk about ex-party communication, and then joking with his buddy about, "Oh, these guys are idiots," and seriously and all that. My goodness, what a violation of your responsibility as an attorney, under the attorney rules, and as being someone who's hearing a case, just like a judge would hear a case. So the appearance of impropriety is there. This is prejudicial to the administration of justice, I think. On so many different levels, this is just wrong.
Wow. Is this a real fact pattern? Yes, it is. Tell us more, Mr. Grogan.
You know, and here, you know, you say, how can this happen? There's a number of people in this room that may understand. A couple of years ago, there was something known as Operation Greylord that dealt with, you know, a significant federal probe into the judicial system in Cook County. And one day a lawyer came in because he had disbarment papers for his client, who was a circuit court judge, removed from the bench and going to be serving time in federal prison. And his lawyer, who I've known a long time, gave me the paperwork that I was going to file in the Supreme Court. And he said, "You know, when my client signed the paper, he looked at me and said, 'You know, it's never your enemies that get you into trouble. It's always your friends.'" And that stuck with me. You know, that really hit, because what happened in the real life situation here were young women professionals. All the lawyers and the arbitrator was a young woman, and they basically grew up together. And that's where the difficulties come in, because, you know, if you know somebody for years, you just sometimes forget that you got to still put that wall up. Yeah, we can be familiar, but only to a point, and then we got to stop. And the problem you see is a practical matter when people just move it a little too far. And the problem is, with modes of communication today, it's so easy to ex parte. I mean, it used to be you'd have to put, wrap the horse up at the blacksmith's and walk into the chambers. And it's so easy nowadays to text, to email. And we're seeing a growth of lawyers texting judges, judges texting during the middle of trial.
What?
Yes, during the middle of trial.
Like personal text?
Yes,
Personal text.
yes.
Oh, that's so bad.
Yes.
Well,
All the lawyers were disciplined here, ranges from censure to suspension. The arbitrator, who was a lawyer, and it's not a JIB issue because not a judge, was suspended for a couple of years by the court for the ex partes.
okay.
There's a question also from Franklin asking, is it now dangerous to send emails to opposing counsel, including a non-blind copy to your client?
Why would that be dangerous? I mean, no, you can send emails to opposing counsel, that's no problem.
No, but I think the question focuses on the blind, is it a blind copy to the client?
I
Non-blind.
think they
Or
put
not.
blind copy, but it said
It
non-blind.
said non-blind, but, well, that's a very interesting question about communications. Can you, have you heard anything at all, Jim or Your Honor, that's come to you about disputes where there's, use of the blind copy and keeping some folks in the loop or that shouldn't be?
I really haven't. I mean, the clients should be informed of everything. They don't have to be informed of every step of the
I
piece
mean, I
of
would think that
litigation,
a
but.
client has a right,
Oh, yeah.
I mean, I sent an email to an opposing lawyer today. I didn't copy my client, but I'm thinking I could have easily copied my client.
You can do it.
Frankly, I don't know if I would have wanted to let my opponent know if I was copying my client, so I might BCC the client.
Yeah, there's
But-
certain things the client has a right to know, and the basic
Right.
things are, is there going to be a settlement, or what's the objective of our litigation? They don't need to know all the minutia, and it's not minutia, it's all important, but of what goes on every time you have discovery. If you want to copy them, you can.
Okay.
Justice, you mentioned a comment when we were talking about emails generally, and I wasn't quite sure what you had said.
Wait for the mic.
You referred to emailing as no expectation of privacy there.
Question from the floor about emailing.
It's a general statement you made in the fact pattern about emailing, then you said, well, there's no expectation of privacy.
It depends on the state. Illinois
Right.
does have an expectation of privacy on it.
In a general email.
Right.
Okay, even though emails can be hacked and there's
Correct.
problems with, there's always a potential for problems with emails. And the reason I'm bringing this up has to do with texting. I have clients who will say my lawyer's not responsive because they define the word responsive as how they define it. My client won't return my text, but the lawyer will leave messages on their voicemail that they just totally ignore because they're young people,
Yeah.
millennials, and when they define what responsive is, it gets into the language of the Code of Attorney Responsibility, and they're 100% convinced that their lawyer is unethical.
What's nice
And
to get it out
I'm
of the way.
wondering what forms of communication can we ethically put in our retainer agreements that people might find shocking, but I will not read your text messages. Okay, can the ARDC say, well, no, that's inappropriate. You cannot, it's getting to the point where texting is almost like smoke signals in the Wild West. I mean, there's no privacy there, but texting, I had a client text me after a court hearing. She couldn't make it because she had well, I got to be careful here. She had another court matter somewhere else and gave her cell phone to her friend. And I found out her friend was texting me and not my client on her cell phone. All because of there's consent, there's no problem.
So what
we
are the
confirmed it.
lessons that we're
But the
hearing
less-
from all of this?
Well, I think you
it's
should
incumbent-
establish,
it's
how
too
am I
much-
going to communicate with my client? Are we going to do it over the phone? We're going to do it by text? We're going to do it by email? We're going to do it by whatever happens? I think you need to get that straight when you get the
Right.
client in the office. Some young people will not, again, if you call them, they're not going to call you back. It's
Hey,
just not going to
look,
happen.
but for those of us who run practices,
Mm-hmm.
I mean, what gentleman just described a moment ago, that's just the way it is now. I mean, and you, the lawyer, in my opinion, have to adapt. That, you know, I mean, people can reach me by texting, they can reach me by email, they can reach me by phone, and like you, I get clients that'll call my assistant Colleen and say, I sent Bob an email an hour ago and I've yet to hear from him. You know, and I'm not happy about that, but we're in a service, you know, we're a noble profession. We're there to serve the client, and if ramping up our communication skills is what it takes to serve the client, I think, certainly for a plaintiff's law firm, that's what you got to do. Maybe, you know, Hugh can get away with not doing that with some claims guy that is, you know, overseeing an appeal, but I can't get away with that with a client who's lost her husband in a car crash. So I mean, I really think that's critical, that we have to step up our communication skills. There's a question in the floor to the left there.
I think the question that came in over the internet about the non-BC, the non-blind copying,
right,
pertained to the fact that you're including your client in it, and then when the other side replies all, they're replying to your client directly, so you're communicating with your opponent's client. I think that's what the concern was. So.
Sure, and that's a good point. I didn't see that, but I think you're right about that. And that raises, well, how about this? You need so let's assume I did that I write a letter to or I send an email to the defense guy, I CC my client openly. Now that client gets a reply all. You know, have you waived any privileges there? Have you created a circumstance that's where the client is now being communicated to by the other side? I mean, that's a really slippery slope.
Yeah. The problem that we typically deal with in regulation is kind of a variant. It's when you're sending the other lawyer's client to CC.
Right.
You know, and essentially what you're doing there is you're subverting her relationship with her client. And unless you have prior authority from that lawyer to communicate in that way with her client, it's a violation of Rule 4.2. That was an old paper-based, you know, analysis, and we've adopted it to the email era. But you raised some really good points.
Yeah, I just delete out the opponent's client who's going to get reply all to. Let's say there might be a partner or two associates that need opponents that get my response, and then I withdraw their client from the email list.
I mean, to me, the lesson I get out of this is, you know, when in doubt, don't. I wouldn't add my client or the other person's client without permission and without, you know, having thought that through very carefully. Let's turn to hypothetical number 4 on slide 19. I'll introduce that to the group. It involves April and Heather. We go from Bob to Bill, now we got April and Heather. April works as an independent contractor for a law firm. Heather, the client, retains the firm to file a divorce, and April is assigned to the matter. Initially, Heather did not know the name of the lawyer who would be representing her. She hired just the firm. And at the time that she signed a contract with the firm, she was told that the firm picks and chooses a client's lawyer based on proprietary algorithms. I read that and I said, you know, I pick it by who's got a little room in their caseload. But, you know, so the firm had Heather sign a power of attorney allowing any firm lawyer to sign the name of a client to any pleading. Heather paid a $20,000 non-refundable retainer to the firm. A marital dissolution complaint was filed in the circuit court, and April appeared as counsel of record. The complaint was never reviewed by Heather. April, using the power of attorney, signed the client's name, signed Heather's name to the document.
Crazy.
Wow. Talk about failure to communicate. So I take it that if Heather's name was signed to the complaint by April, but it's going to appear as a verified complaint. Aren't there some rules that go along with verified complaints? I think so. How did this lawyer slip up, Jim?
I'd rather pitch it to the judge.
Oh, thanks a lot.
Okay.
Well, first of all, that's this whole power of attorney thing. Is that going on in legal circles these days?
It's not going on at Clifford Law.
Okay. I suggest it not go on, but you do what you think is right. First of all, the client's supposed to guide the litigation, not the lawyer. The client's supposed to know what's going on all the time. So for a lawyer to sign a complaint without the client even seeing it, wow.
What do you think, and Jim, has this come up at the commission where a lawsuit is filed and talk about best practices of communication? Should the firm, as a standard policy, even if it's a form letter, say, dear client, here's a copy of the complaint that was filed in your action today. If you have any questions, please call me. Dr. Parikh, is that a good strategy for communicating with people?
Yeah, I mean, I think you have to give them an opportunity to give you input, right? And even if they don't have any, but you have to give them an opportunity for input.
Opportunity for input or an opportunity to be informed? I mean, there's a difference. I mean, do you really want April
Yeah.
talking to Heather about how to plead a complaint correctly?
Yeah,
I don't
maybe
think
it's just,
so.
maybe there's just I think you have to make a decision based on who your client base is. I mean, and who your client is. Obviously, some clients will want to be much more involved, especially if you're in the commercial world. But if you're dealing with consumers who aren't as sophisticated, then maybe it's just an opportunity to keep them informed.
Right. And I think the point here, at least for me, is that it's, I think it's dangerous this too is from a real case?
Not a formal case, but we've had some of these at the investigative stages.
Okay. Jim, what's your take on this?
Well, if we could show slide 29, because, when we're dealing with the attorney-client relationship, and essentially it's an agency relationship, and the lawyer is just the mere agent for the principal. So it's the client's matter. And does the client really know what that power of attorney means and the significance of it? Now, nothing's, intended to, none of the ethics rules are intended to upset agency law. With communication with the client, they can say, I'm not going to be at this closing. You go ahead and close. I'll sign whatever you want. That's fine. No one cares because the client knows what's going on. The lawyer explains things. Fine. It's where you get into this unknown territory. Just sign this power so we can proceed on your behalf. I just point out that you have to watch out for 1.2a because the clients have to make the big picture decision. And as far as, do the ethics rules require you to send the client a copy of things that you file? And the answer is, of course not, no. Because it's up to the individual relationship between attorney and client what's going to work. There are some of your clients that may want to see everything, and you're of a mind, what harm can it do? There are some clients that you say, oh gosh, I'm not going to send that motion to continue because they'll say, why didn't you hurt them? You're in charge mostly with how the matters proceed. They're in charge of the big picture matters.
There's an interesting question here from Muriel online that says, if the client lays out specific questions to be answered by defense counsel, can I just forward that email on to opposing counsel from the client? Should I cut and paste from it instead and forward it? And also, do we have to respond to all text messages?
Wow.
Okay, so we have two questions there. Let me take it, at least from the practice perspective. I think the answer to do you have to respond to all text messages, I think the answer is no. I think you do have to respond to any text message from a client. So in other words, if I get a text message from my opponent, which I rarely get, I get emails from my opponents. And as it relates to the first part of this, I don't think I'd ever, if my client was sophisticated enough to craft questions that are part of an exchange between me and the defense counsel, I still would never just send this from my client. Here's a copy of the email from my client. I'd write a letter saying, writing on behalf of the client here, and we have the following, inquiries of you, if that's the format that's applicable.
Yeah, I agree.
Justice, you had
I
any
agree,
different
totally.
take on that?
No.
Jim?
Yeah, I just like to just use the word immediacy because text messages imply an immediate response.
Right.
Emails, you're going to get to this right away. Sometimes a lot of things we do, we want to think about it. I hate sending emails to an opponent. Luckily we were kind of lucky. We have a smallish bar. There's only about 25 lawyers who regularly practice in our system. But most of them, I'd prefer to pick up the phone and communicate with them one-on-one. Yeah, I'll respond back in a certain way. But I think the in large measure here, when you're dealing with non-clients, you have to be able to protect your client, protect the process, and immediacy sometimes is the worst, responding back in that form. Look, I respond, I know lawyers that say, look, I respond this way. I'll respond back in a day or 2 or 3, if at all, but I'm going to do it in this way.
Yeah. Sarah asked me about this at the beginning of the program about how, we do things. And is there a rule, for an example, in the office that you have to respond within a defined period of time? And I mean, I think it's reasonable to expect your lawyers or a lawyer to respond to a client within 24 hours. But at least from my perspective, running an office as I do, communication is critical to our relationships. And I'm not going to be happy with a lawyer that where I'm getting a phone call from a client saying, I've called this guy 6 times and I can't get a return call. I kind of beat those folks up in my office. And I think most of us would if you're in the management position.
But then there's a client that calls 20 times a day, which
Yeah,
is a
right,
problem,
right.
but you have to understand. So
But you know what? I think it all depends what you do for a living. I mean, I think that, for example, tort lawyers and divorce lawyers and probate lawyers almost have to have an inexhaustible level of patience because you're dealing with people who are traumatized. And I see it every day in my practice where I'll have one client who loses a loved one and they're stoic, they're calm, they're collected, and I have others that I talked to a lady the other day. Her husband died 3 years ago, and she can't have a conversation with me on the phone where she's not crying. I mean, it's just so many people act so differently to these things, and we shouldn't be judgmental about how the clients do react. We're their lawyers, and it's our job to be there to help them.
Absolutely.
Okay. So how about we turn to hypothetical number 5? Yes. Hold on, we got a question from the floor. Can you give her the mic, please? Oh, there you go. Let's go. Sorry.
Another question about hypothetical 4 as well is nobody brought out the fact that April is an independent contractor. She's not a member of the firm. She's not an employee of the firm. She's an independent contractor. And so there's a question of whether that power of attorney would even apply to her. But there's another issue in there, and that is, does the client have a right to know who the work is being farmed out to? Do they have a right to know who's doing the work?
That's
Sure.
right.
That's a
Yeah,
whole
good
other
points.
wrinkle on it.
Yes.
Yeah.
Thank you for mentioning that because it was intended that that be one of the focus of the problems.
Yeah. Another question here?
In that last scenario, it said that the client, the lawyer had the client pay a non-refundable retainer of $20,000. I thought retain is, you can't use that term, non-refundable.
I don't talk about money. You guys want to handle that?
So the question from the floor is, can retainers be non-refundable? Basically.
What if the client fires the attorney in like a month, and then there's like $15,000 worth? I mean, she can't get that back?
She might not be able to get that back.
Is there a rule on that, Mr. Grogan?
These are good questions. In some jurisdictions, it is unethical to charge a client a non-refundable retainer in certain substantive areas. For example, you're a divorce lawyer in New York State, you can't do that. It's unethical.
What about Illinois?
Reading just the ethics code, okay, there is no mention of non-refundable retainers. So you can go ahead as a lawyer and charge a non-refundable retainer. But if a dispute arises, then the money you retain is analyzed on the basis of a rule that we don't have, a slide we don't have, which is 1.5, which is the fee rule. Is it reasonable for you to retain $20,000 under the facts presented here? And if that client came in and put $20,000 on your desk, and the next day, for the divorce, and the next day he gave me flowers, he loves me, I don't want to divorce him anymore. Well, you know what? You can, deduct your reasonable fee, but by you holding all $20,000 in those factual it's probably going to violate 1.5. There might be scenarios where you are so significant in your industry and your time is so costly that might be a blend in a reasonable fee component. That you would drop everything for a month, and you're at the top of your game. You know what I mean? So it's fact by fact, but you know, we view it in regulation in Illinois and most states. There ain't no such thing as a non-refundable. You analyze it under the reasonable fee rule.
There you go. Okay. Jim, could you keep the floor and introduce us to hypothetical number 5?
And that's Valerie and Veronica. And Valerie works as a law clerk for a Supreme Court justice in her state. She's a licensed lawyer, of course, and one day she decides to go to the courthouse to attend an oral argument before the state appellate court involving an important municipal eminent domain issue. While there, during the course of oral argument, she pulls out her cell phone and begins tweeting comments such as, "The presiding judge, Veronica, is such a clueless soul."
I know Veronica Vox. She is not a clueless soul, but continue.
Pray that her colleagues help her comprehend what's going on here. She also castigates some of the lawyers for the property owners as being idiots, fools, and 10-watt bulbs. The day after the argument, she reads a newspaper account of the case in an electronic edition of a large media outlet, and she begins posting comments under the name Court Watcher 1, in which she opines the appellate court should reject the arguments of the property owners, who she describes as slumlords and lying pond scum and predators of the poor. There's some facts.
Well, there we go. Is truth a defense? I don't know. Is this a real case? It is. Here we go.
Two
again.
real cases.
Two real cases. Okay, so I guess my question is, who's the client that we're worried about communicating with here?
Well, this has to do with attorney responsibility, I think.
Right.
And if you're working as a clerk, a law clerk for a judge or a justice, they're governed by the rules, of course, because they're lawyers. And Illinois, again, doesn't have a special rule for persons that work in this area, but we should have it, which this scenario makes me want to work on one right now. But there's duties of confidentiality, loyalty, and respect that law clerks and other persons have for the justice they're working for and for the judiciary as a whole. So this would be a complete violation of confidentiality, loyalty, and respect. Because this law clerk works for the Supreme Court justice, and she's giving opinions about, number one, an appellate court justice and other lawyers. I mean, that is absolutely outrageous, ridiculous. It's got to violate some part of the attorney's code. So I would fire this woman right away. That's what I would do. But there is this dissemination of this information only makes it worse because it's going out, you know, to everyone online. So that exacerbates it as far as any discipline that would be.
What if she sets the privacy controls on her Twitter account to only let her best friends see this?
I still think it's a violation.
Why is this a violation? I mean, I don't like it any more than anyone else does, but I mean, why, you know, this is opinion.
Well, but this is a case, maybe, so the appellate court, it may come before her justice when it goes to the Supreme Court.
Right.
And she's already giving opinions about it. That's just wrong.
Is it okay if she's a trial court clerk?
Maybe. I don't know. Trial court clerk. Oh, a law clerk for a trial court judge. Probably not. There's still a duty, again, of loyalty and confidentiality that clerks have to the court. And for them to be doing this kind of thing violates those duties. So I still think it would be wrong.
Interesting.
When you say that, do you believe that both of these two actions were violated with her duties?
The question is, does the judge believe that both of these actions violated her duties?
Because I see a difference between the tweet, which is typically identified with the person putting it out there, versus the second one where it's an anonymous comment on a news story in a public forum.
Quite possibly.
Right.
And this is her opinion about Justice Fox. I mean, First
Right.
Amendment, maybe.
Another question from the floor here, gentleman, right there.
Since this tweeting was taking place in the courtroom while the oral argument was going on, isn't there a question of contempt here? And when the judge finds out about it later, can they issue a
I like
citation for
that.
contempt?
And where's the deputy sheriff that should be stopping this tweeting?
There we go.
But possibly, but, you know, it's so, people can do it so discreetly, you have no idea what's going on. They're so
Right.
intently watching what's going on.
So Jim, we're
Yeah, that could be,
we're
yes.
intrigued. What happened in these two cases?
And you know, these are two different scenarios. And the first involves a real discipline case coming out of Kansas, where there was a lawyer disciplinary proceeding initiated against the former attorney general and Johnson County District Attorney of Kansas. So basically, they charged the Attorney General with engaging in lawyer misconduct, and it was a horrendous media case there. And during the course of the oral argument, where the lawyer regulator is asking for disbarment, an employee of the appellate court is watching live streaming, as we can do, of our Supreme Court, the oral argument from her office at the appellate court, and tweeting out on her computer about this guy is going to be disbarred for 7 years, and other inappropriate comments. She thought only a few select people could see it. She did not know that once committed into an electronic code, it never dies. And within a day or two, the lawyer for Phil Klein, the former Attorney General, basically said, and why is this so significant? In that case, the former Attorney General filed a motion to recuse 2 of the justices because he represented them. 5 justices recused themselves. So you're saying about
Who's going to hear
Justice
the case? Yeah, right.
3 trial judges and 2 appellate judges sitting as designation. So here we have 2 appellate court justices, and here's an appellate court employee. So what happened? Well, the Attorney General was suspended indefinitely for misconduct. She was fired within a day or 2. And she was the subject of public disciplinary proceedings. Because, and you know, here's the interesting thing. There is an Illinois case from a couple of years ago where the Illinois Supreme Court essentially said, when you're a lawyer and you work for the court system, your client is the court. So the relevant ethics rules apply. So, because you don't really have a specific, many times, judicial rule. So there is that. With the second scenario, which I think is you know, more of a discussion point, is how far can you go in being a troll? You know? This was taken from a case where there have been no public disciplinary cases, but this has led to the resignation of the longest-serving U.S. attorney in the last couple of years, a guy named Jim Letton, who was the U.S. attorney down in New Orleans. Because he found out during a case of a couple of very notable cases, including a case involving shooting of a number of people on the Danziger Bridge in the wake of Hurricane Katrina, that there was a situation that they're prosecuting these police officers, and 2 lawyers and his staff are trolls on NOLA.com. And what does that violate? Well, what the federal judge that kicked out the convictions of all the police officers in the wake of prosecutorial misconduct was that slide 37. It violated Rule 3.6.
Wow. Well, I think the moral of the story here is don't tweet, but about your cases. Gosh, what's the question?
From Janine, who asked, what if an attorney is being pressured by opposing counsel to enter into a confidentiality agreement whereby the documents will be produced for the attorney's eyes only? How can the client make an informed decision if they can't even be informed of the evidence that's being produced?
I'll tell you, my take on that is that the lawyer should not agree to that ever. For a myriad of reasons, because, and it's, you know, nowadays with protective orders, you have to be very careful about that. Let's go back to the example where we had the independent contractor lawyer working for the firm. The lawyer signs something like that. Is that person part of the firm? I mean, there are a lot of issues there. So negotiating these things, at least from my perspective, is very. You have to be very, very careful. Judge, you were shaking your head there.
I agree with you, once again.
Yep.
And Jonathan is asking if you have an extremely demanding client who's constantly sending emails asking very specific but mostly irrelevant questions. What is my obligation to answer each and every one of these questions?
Again, from a practice perspective, I would bring that client in and have a lengthy meeting and go through each and every one of them. Again, it's, on the plaintiff side anyway, we have clients like that, and I think it's our obligation to try to work them through the system and educate them, and help them out, answer their questions.
The rules only require that, and it's the communication rule. We don't have a slide. It's Rule 1.4, but all you have to do is promptly comply with reasonable requests for information. And sometimes you'll have clients that go overboard. You try to be patient, you try to do it, but you're only expected to communicate where there's reason involved.
What about obligations to prospective clients? Someone's asking.
Yeah. To prospective clients, from the practice point of view, you'd be very careful about that because have you created an attorney-client relationship by answering? And I think you may well have. Question from the floor here. Please use the mic because that's the only way everyone can hear.
I appreciate this, Mr. Clifford. I agree with you on your point. You sit down with that client, but I want to raise an issue, and not to compare practices, but if you're doing a lot of plaintiff's work, you don't have the same economics as an attorney who's on an hourly rate. And if I bring my client in and bill them and answer their 40 frivolous, stupid questions just to be appropriate, and then I present that bill to the client, then I'm faced with an issue about reasonable fee.
But how is that different from me having a client who says, did you talk to this witness, that
Right.
I mean, I tell people they can buy as little or as much investigation as they want. And why wouldn't you say the same thing to your client? I can answer 400
Right.
questions.
I agree with
it's going to cost you.
Right. I do agree with you 100%. My question is more to Jim. Would the ARDC ever say, well, a lawyer needs to cut off that process with his client and not? Are we engaged in a way where we're just in effect overbilling our clients simply because we should know better that we have a client that's just over concerned about frivolous issues?
A lawyer's time is money.
That's right. Okay.
Period. And you got to respect that. It's how does the lawyer communicate to the client that, look, you call me up, I'm more than willing to spend time with your daffy questions. You're going to be more artful, of course, but you're going to pay for it.
There's an interesting question here from a guardian ad litem who is saying, who is my client? Many of my mentally ill respondents call all too often. At times, I'm not sure how to handle this.
Seek
Guardian
the
litem-
advice of the justice in the court here.
The
Your
guardian ad
Honor.
litem does not represent their ward or whomever they're involved with. They are acting in the best interest of that person. So I'm not sure how to answer that question, but that's not their client. And the question is, do I have to talk to them?
I'm going to say, yeah, it sounds like that's the question. That
Well,
we have
yeah,
to talk to them, and
of
I think
course.
reasonably so, but I think if there's a dispute or an issue, wouldn't you go to the court that appointed you?
Yes, because they're an arm of the court, the
Correct.
guardian ad litem, so you come to the court and ask for advice on how to handle that.
Right.
Okay.
Thank you.
All right, let's, Jim, I think, thank you for that, and Sarah, how about telling us about Mick and Joe?
Another unsavory story. So Mick is a rich man who wants a divorce. And he meets with Joe, who's a Chicago divorce lawyer, in Joe's law office. Mick brings his new girlfriend, Elvira, who's an exotic dancer, and tells Joe that his wife of 30 years, Nora, refuses to acknowledge that he has a soul-cleansing relationship with Elvira. He relates that Nora is a member of an ultra-conservative religious community and would never agree to a divorce unless a creative solution was used. So Joe says, what do you mean by that, Mick? Mick says, well, if you could show that Nora had extramarital relationships with other men, many men, in fact, she might agree not to contest the grounds of the divorce because she's really concerned about her reputation and she wouldn't want to be dragged through the gutter. So she might be amenable to a lesser settlement if you threaten her with in that way. So Joe says, well, Mick, has Nora ever actually been unfaithful? And Mick says, well, the virgin Nora? No way. Are you kidding? She would never even dream of it. And then he proceeds, now how much of a retainer do you want? Name your price.
Wow, you'd be telling me this was a real case too.
Oh, my God.
Okay. Let us count the ways why we have some violations here.
I just think it's an absolute fraud. He's trying to make the lawyer make things up about this poor woman, who is a saint, of course. Name your price. Hand in your law license then, if that's what you're going to do, make up frauds about people for money.
That's a total violation of the rules.
But a lawyer's an agent.
Please. If they tell you to do something fraudulent, you're still going to do it? I
don't
don't
get
think so.
caught.
Yeah, if you don't get caught, but,
Well,
no.
I mean, I think this one's pretty obvious, but, in terms of the improprieties here. But Jim, did something like this really happen one day?
We vary this, but it's really common to have clients walk into a lawyer's office with, how about if I try it this way? Or how about I try it that way? And how do you communicate with the client that there are limits on the scope of their advocacy, like fraud? How best to counsel a client?
Well, what about the case where the client says, I took a header and I slipped and fell in front of a store, and it was on their property, and the lawyer goes out and he looks at and it's a company, it's a big company, but he looks at their sidewalk, and the sidewalk is in a good state of repair, but he notices across the street at a store closed that it's a really bad sidewalk, so he takes pictures of that one, and he shows them to the client saying, was this where you fell?
Is this a hypothetical?
Yeah, I think it is. I think it is here.
Based on a real case.
Exactly, based on
Not
a real
in our
case. Yeah. You can't do these things, right? Oh, gosh.
But
All right.
this is, in terms of client communications, what is the strategy for
Right.
dealing with the client that's trying to get you to push the edges, right? I guess you just draw a bright line. That's what you do.
What would happen, though? Let's take this down, either my example or even this one. But so the lawyer does the right thing. The lawyer, says, listen, there's no amount of money he's going to get us to do this. It's improper. And this rich guy, Mick, leaves, but the next thing you know, you see the lawsuit filed, okay, and in the hands of a different lawyer. Do I have an obligation about that if I'm the lawyer who's kicked the client out?
Jim would know better than I do, but I think lawyers are mandated reporters on some things if you know a crime has been committed. But I don't know about a violation of the rules if you're a mandated reporter. Are we?
Well, I think that there is a slide.
We're mandated on crimes and.
Slide 33.
Slide 33. So we talk about 106B, 1 and 2. Don't those create a duty for the lawyer in that circumstance to step forward?
Quite possibly.
How is this different than the lawyer, Jim, who has the client that comes in and confesses to a murder, and here's where the body is buried, and...
I'll be honest with you. I use this hypothetical in every law school exam. So if you've got a kid, tell her it's gonna be there. But I add Bob's twist to it, because I want to see. It's one thing for the client to come in, and the lawyer, it's doing just what the lawyer should do. I can't do that. Here's why. I've got to express the limits. Now, if you want me to represent you, we've got to do things a certain way. You've got to be candid. We've got to find another grounds for this divorce. But when they walk away, never retain the lawyer, what does Bob do when he found out that this client has gone to another lawyer? Probably deceive that lawyer. Maybe.
Maybe not.
Or maybe not. Maybe he did the same thing and he found someone, that's a shark. Okay, great. What do you do then? And this is where the rules come about, because you have very limited, you mentioned mandatory reporters. Mm-hmm. If there is conduct that could cause death or serious bodily harm to another, we have an affirmative obligation to do something about it. Mm-hmm. Okay, that's obvious. What about the client, however, who has said to you, I want to engage in fraud, but your services aren't used? That's where you look at this slide, because this is another exception to confidentiality. And basically, you can, according to the rules, prevent a client from committing fraud that's reasonably certain to result in substantial injury, even of financial nature. And in furtherance of which the client has used or is using the lawyer's services. Well, that hasn't happened here, right? Haven't? No, that has happened. So where's there another rule? Slide 34. to prevent, mitigate, or rectify substantial injury to the financial interests or property of another reasonably certain to result in or has resulted from the client's commission of a crime or fraud of which the client has used the lawyer's services. Uh-oh. And that's why I put it in the exam. Haven't used the services. So what do? You're really in a box, right? You've got to protect information. Yes, I murdered 5 people, but I'm never going to murder again. You have a different obligation of, I murdered 5 people and I'm going to keep murdering. Okay. Then I may have something to do about it. But these rules about permissive withdrawal are very limited, or permissive revelation. They're very limited. Were your services used? And absent that, most states would say.
Yeah. But you know what, you mentioned that you didn't intend to use the word withdrawal, but I'd like to ask you a question about that, staying on this. So now let's assume the lawyer, Mick tells the lawyer that, in answer to the question about the wife, that yes, she is very promiscuous, and she, I mean, my God, the list is a mile long about how many men she's been with, and I want, so now the lawyer takes the case, and then along the middle of the case, the lawyer discovers that Mick misled him and was lying about it. And now the lawyer brings Mick in and says, hey, what? And he says, well, yeah, you know what? Yeah, I lied to you, so what? We're going to keep going with this case. What is the lawyer's obligation to withdraw at all? A. B, what is the lawyer's obligation relative to slide 35, candor with the tribunal?
That's it.
Oh, go ahead, please.
The fundamental obligation here is the lawyer is an officer of the court. There's been some development in these rules over the course of years. You've got a conflict. Your client wants to win at all costs. You've got a duty to zealously represent the client. On the other hand, you're an officer of the court. You can't lie to a judge. You can't show, phony things to a jury. You're limited in what you can do. And 3.3 essentially tells you that. A lawyer shall not knowingly do this. Well, you didn't knowingly do something. So the next slide tells us what happens where you represent a client in an adjudicative proceeding. This has been construed as depositions, too.
Okay.
Okay. Who knows that a person intends to engage, is engaging, or has engaged in criminal or fraudulent conduct shall take reasonable remedial measures, including, if necessary, disclosure to the tribunal. This is really a dense pack sentence. And it's really kind of worrisome in that regard, because the bottom line here is you can't put on junk, and if you find out your services have been used, that the client has lied to you, the one thing at the very least you have to do is a reasonable remedial response. What's that? It could be counseling the client to let's go clean, let's try to go back in, let's try to survive, but I can't continue. Then the next, if that client refuses to do so, is to withdraw. And then where we're starting to see development is how far do you go in withdrawing? And a lot of people are saying, look, if your mere petition to withdraw won't cure the lie on the court, you may have to disclose to the tribunal.
All right.
This is why you don't do things as a lawyer without the aid of an attorney. I'm telling you, when you're really in this horrible position, you got to reach out to somebody who knows this area of practice, because there's all sorts of concerns. All sorts of concerns.
We have some other interesting questions coming across on the internet. Barry's asking, what do you do when a client threatens physical violence to the lawyer and his family?
Call the police.
What about those who are working pro bono and not charging for their time? What's their issue in having to stay responsive to all the questions that are being asked?
The fact that you're not being paid doesn't matter.
Well, there's still the same responsibility.
Same responsibilities under the code, right? All right. Got another one? We're on a roll here.
Okay, there's a lot of questions about Rule 1.6, which I think came up before, and that is, does the panel think that a change to Rule 1.6 would be desirable to address the blogging lawyer, First Amendment questions about it, and if so, how should Rule 1.6 be changed? They're also asking the background, the genesis of Rule 1.6 and its broad adoption. And isn't comment 4 to Rule 1.6 relevant to the issue of trying to merely delete the name of the client? These are from all various different people.
You know, let me speak to that. As you know, I think is fairly well known, I'm pretty active in the ABA and the CBA, a little bit of the ISBA, and I have to tell you, I think as members of the bar, like that person who put that all together, I'd really encourage them to communicate with the organizations who are analyzing these things and helping promulgate these rules. This is why bar membership is so valuable. It helps make you a better lawyer, and it gets you the opportunity to be engaged. So, because these are the people that are, drafting these things and are debating these things, and so please, whoever asked those questions, follow up and with your ABA, CBA, or ISBA reps. Jim?
I got to tell you, the person who just wrote in has a very significant point about comment 4. Now, we're really getting into WOG City here, when we're talking about, I'm a WOG here because I'm into comment 4. It's like the federal lawyers, well, they're dealing with this paragraph. Well, tell you what are the comments? What are the significance of the comments? They tell the ARDC, interpret the rules with a common sense approach. Interpret these rules this way. And comment 4 basically says, it's a little bit of a limitation, but it basically says, is there any way to tie back these facts to a client? Is there any way that client could be materially harmed by virtue of what you're revealing? So we take into account as regulators comment 4. But on the other hand, the rules are broadly drafted. Until 3 years ago, 4 years ago, we still had the word telegraph in our ethics rules. So there's a little bit of a lag time. And a lot of time, with blogs, Twittering, there are changes on the horizon. One change, slide 31, deals, and this is a little bit away from the question, but Model Rule 1.6, a lawyer shall make reasonable efforts to prevent the inadvertent or unauthorized disclosure of or unauthorized access to information relating to the representation of the client. Isn't that nice? Isn't that innocuous? Why is that there? Why is Illinois Supreme Court soon going to consider this part of ABA's 2020?
Right.
And you read that and you think it's just noise until you realize, oh my gosh, what are they saying here? I got to know new technologies. I have to prevent people from stealing client information through use of those new technologies. Right. As part of the provision of being competent, I've got to keep abreast of this stuff.
That's that brave new world that I talked about, that, you got to get with it. I mean, I have young lawyers who work for me, and I asked them, what's your home phone number? And they said, well, we don't have a home phone number. They got the cell phone that you're paying for. That's my home phone number. All right, so, and you guys who are watching know who I'm talking about.
In relation to hypothetical 6, several people are writing in and asking if the lawyer could say that it would be a fraud because the attorney-client privilege is waived with the girlfriend in the room.
Ah, there you go.
Great question.
Yeah, very good question. Possibly.
Possibly.
I haven't done all the research yet, but it could be.
No, it's a good point. My answer would be yes to that, actually. So, who's Elvira? I mean, she's the girl.
Who is Elvira?
Who's Elvira? She's a girlfriend.
She's a stranger.
Yeah, exactly.
However,
soul cleansing.
However, it destroys common law privilege. But remember, Rule 1.6 mandates that you protect a far broader scope of information. It's information acquired, of which one small component is privilege.
Okay, there you go. And on that note, our next and last hypothetical is number 7. It's really very long, and I would ask that maybe if Jim, you could, Justice Connors.
I'm happy not to read it.
But I know you can handle this any way you want in terms of, you don't have to read it all.
I can summarize it.
Okay.
Okay, Duff Firm. He prepared all this.
Starting at slide 24.
First of all, Chicago law firm O'Murphy and Malloy want to adopt an aggressive marketing campaign. And they want to come and they hire a marketing company to give them some new concepts and propose to them what they need to do. First bullet point. In all future internet, print, traditional media, blah, 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 the Malloys should forget about O'Murphy and Malloy, and because it's too South-sidey, which I object to.
Nothing is too south. I love the South Side, born and raised. Anyway, instead the firm should use a better approach and call themselves Duff Firm. Or is it Duff Firm? I don't know, whatever.
Duh.
Anyway, they should also create marketing logos, have logos on glassware, pen, golf balls, hats, everything, and hand them out wherever they possibly can. Here's another thing they should do. Begin a marketing campaign that encourages consumers to call a 1-800 number where they could speak to a lawyer staff member who would provide legal advice on a charge of per minute basis. Wow. Before speaking to the lawyers, they would have to provide their debit or credit card information. And staff members would inform that the firm could provide a longer and a written opinion outside of the telephone arrangement if they want one. That would be an added cost as well, and charge probably per minute. Also, the firm wants to go into class actions as well, and they want to do a marketing specific services on that as well. They're going to have phone calls coming into a phone bank. The caller provides information to a non-lawyer. The non-lawyer then signs out a retainer agreement. When the retainer agreement comes back, the firm will begin communicating with the consumer. Another bullet point. This kills me, Jim Grogan. As all the lawyers employed at the firm are a bit plain of feature. They must be Northsiders. So the marketing company proposed to have photographs of models appear in the firm's commercials that appear in local markets and on YouTube, and the models would not be directly identified as lawyers, but these strikingly good-looking, well-dressed people would serve as the firm's persona. And also, let's have an aggressive e-marketing campaign. Let's hire a search engine optimization company that would put pop-ups. Your pop-up would have come up whenever people do look up for lawyers. And also, the last thing we're going to do is get lead-generated referrals by going on findalawyernow.com. You've paid a fee to findalawyer.com. They would put your name at the head of the priority if somebody would go on findalawyer.com, and they would pay the same fee. You just pay them a general fee, and they would get back to you. Even if they sent you 0 clients, you'd still be paying the same fee. Okay.
Wow. Sound like there's some fine ideas in here. No, I'm kidding. I want to.
Okay.
So, Judge, when you read this, what was your reaction to these bullets?
Well, the first thing I thought of when they said, we're going to call it the firm, what are we going to call your next firm? Moo and Oink? I mean, let's have some respect for ourselves, lawyers. I mean, come on. What's wrong with using a lovely name of Omer Fied Malloy? But anyway, I think that puts the law community in a negative light, the firm. Unless you're Irish and you called your grandfather Da, and it's kind of cute because you're referring to your grandfather. But no, I just think that's a negative thing.
But don't you think that the ketchup's out of that bottle now?
Oh yeah, well people are. It's all word names now for big firms. But again, I think there's got to be a line somewhere that we show respect in the law community for one another. And the firm. It seems disrespectful to me. But I would let them have it. It doesn't violate any rules, I don't think.
Right.
You can do it.
Might work in Hegwish. I mean, come on. You know, in fact, maybe the coach is entitled to a royalty. I don't know.
Well, that's what I was thinking. You could put Ditka up there
that's
on
right.
your website as well. One other thing about as far as handing out things that have your logo on them, golf balls, is that soliciting business? Is
I
that
hope not.
appropriate? But what some of the cases say is you have to be very careful to put on those things that says advertising material.
No, the
That's
new
what some
one
of the
this
cases
winter
say
has
now.
been, at the front desk, we have these pens that have the stuff that you squeeze in your hand, the
And
the
that has your name on
sanitizer. But it does happen to say Clifford Law, 312-899-9090. I mean,
Perfectly fine. It's
but
at
it's
your
marketing.
office.
It's there's
Yeah.
a cottage industry out there that helps lawyers market.
Oh, no, I understand that, but again, it could be construed as soliciting. So you've got to be careful with that. If
Okay.
it's going to be advertisement, you have to put on there as advertisement material. As far as the charging per minute, does anybody charge per minute?
That's interesting to say that.
Hold on, there's
No,
a question. I'm talking about bullet point number 3, we're talking about people call up and they charge you by the minute for the legal advice.
Credit card
Yeah.
information.
And the credit card
On the
number.
credit
So
card.
you're aware, software programs do have clocks on them, time slips in different programs where you're on a call and then you click the button and it'll say 0.76.
Sure.
Now, that could go into a bill and
Oh,
get
yeah.
you're still charged, your retainer may say hourly, but when it's all added up, it could come out to a minute number.
But that's a matter of how you do,
Yeah.
again, that's a,
All
you know, go
presentation.
back to what Sarah told us in the very beginning about what clients are looking for, and one of them is transparency on fees and expenses. And I think if there's disclosure there and it's part of the agreement, then that's okay. That's not a problem.
One of the important things lawyers have to remember, though, is to keep their clients advised of the cost. If somebody says really quick, and it's $1 per minute, blah, 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 then all of a sudden you talk to this person for 2 hours, they're like, wait a minute, or $100, or whatever the cost is per minute, $500. They have to be reminded of that. So I think that's important for lawyers to know as well.
Jim, what's showing up at the ARDC, like, and I find this one about this class action work, 1-800 class act, and a non-lawyer deals with the client, then they send out retainer agreements. If you see what's going on in these aviation cases, to show you what's going on, the families will receive by FedEx and with a return FedEx a cover letter telling them how sorry they are for their loss. Here's our contract, sign here and return it in the FedEx envelope. That is going on, okay? I mean, that's not materially different, I suppose, than how about this retainer agreement that was prepared and the lawyers never talked to the client? Are you seeing things like that?
All around the country. And, a lot of states, there are differing rules dealing with marketing practices and how to get your name out there and new ways to, especially with the last portion, with the lead generator. Yeah. People are struggling with, well, how can I do this? Because, renting out a billboard isn't going to cut it. So how can I do this in a cost-effective manner? As a general rule, when you're talking about marketing practices, whatever is truthful goes. I mean, is okay. Even though you might not like the message it sends, as long as the message is truthful, why is that? It's the First Amendment commercial speech doctrine that essentially a consumer has the right to receive truthful information that make that consumer's decision about whether to hire a lawyer important. So when we talk about a lot of these marketing strategies, they don't violate any rule. They really don't. There is a difference between, I should note, general marketing campaigns, golf balls, billboards, TV ads, and targeted solicitations, to use that word, which is in another rule. And that requires that advertising advertising material be affixed to it. That's when they email. You have to take into account the U.S. Supreme Court when you're talking about people getting FedExes.
Right.
As long as it's not 90 days within an air crash,
Right.
you can go ahead and send stuff out. You can solicit. You can target. As long as you meet the state's qualifications dealing with direct mailers. Why do we allow this to happen? Isn't this shameful? It's because the U.S. Supreme Court says it can happen.
Right, right.
With case law.
And when we talk about websites right now, and you do, again, stay with this thing about the class action, isn't there an issue of an obligation of the lawyer to communicate up front their competence in an area of practice? So if you go to slide 27, here you have these lawyers, out there marketing for class action on X product. And yet they don't have an engineer on board, they have no experience with this stuff. I mean, isn't there some fairness obligation about disclosure to the clients of your competence?
I don't know about that. You're licensed to practice in all areas of the law, but, the buyer beware. It's sad but true, I think, that if you're going to hire someone that you haven't investigated yourself to do this very important work,
Right.
that's unfortunate.
But remember, you can become competent in the field.
Right.
It depends how you market yourself. There was discipline. We don't like advertising cases. You lose them, you pay attorney's fees. But I will tell you, there was a case a couple years ago where the Illinois Supreme Court got upset. They didn't get upset. Courts never get upset.
No, we're very kind.
They imposed sanction because of the fact that in the Polish-American community, in an ethnic community, a lawyer was marketing his services over radio, targeting that market, saying, I am the lion of the courtroom. They're very slick ads. Roy, great, guy never tried a case.
Okay.
That's where it's a problem.
That's a Lanham Act case.
We've got another question from the internet here.
Oh, loads. What does an attorney do when the court will not allow the attorney to withdraw from a case? For example, it is the regular position of Cook County probate judges in decedents' estates, especially to not allow an attorney to withdraw unless there is an attorney who will substitute into the case.
Justice Connors.
No comment.
No comment. That's a
It's a very touchy subject.
A conundrum.
Yes.
Is that a conundrum as opposed to a dilemma?
Both of them.
You know? I don't think we're going to give you an answer to that one today.
Well, then we have also, and going back to Elvira, there's a few people who have been asking about the Himmel issues involved in that
Good people.
hypothetical. Oh, they're flying in here. Let me tell you.
Some people don't know about him.
Yeah.
Here's with Himmel, and that's when we're taking Bob's example of he reads, so some other lawyer has filed this action, obviously premised on fraud.
Right.
Does Bob have a Himmel obligation? And we have the slide, Rule 8.3, that deals with that.
Reporting.
What do you think?
Again, I think the reporting requirements is for only serious harm.
Serious stuff.
For a crime.
Fraud,
I don't think it
crime.
applies that you're mandated to report for a violation of the rules.
Here's where, you're right, in Illinois, but it's knows. Does he know that the other attorney has? That's a critical factor. And the Illinois Supreme Court has said knowledge is an absolute certainty, but it's not suspicion. Right now, you're just dealing with suspicion.
Okay. Okay.
There's
One more.
also a question actually directed, it says, to Jim Grogan, in the case in Ray Caravitas, and how that pertains to client communications, and what impact this opinion has for lawyers acting as executors or trustees.
For those of you who don't know the Caravitas decision, it was a 2013 case from the Illinois Supreme Court. It's significant in lawyer regulatory circles. Why is that? Because the Illinois Supreme Court said to the ARDC, in future, when you plead cases where a lawyer is acting as a fiduciary, not as an attorney, then you can no longer charge common law like you sneaky old guys used to do all the time. In other words, if I'm a trustee, if I'm a GAL, if I'm the executor of an estate, if I engage in a breach of my fiduciary duties, but it doesn't involve fraud, deceit, where there's a specific ethics rule, ARDC has to tie a violation to a specific rule. So if you're a lawyer fiduciary and you don't violate a specific ethics rule, no jurisdiction for ARDC, bottom line.
What was the case?
Caravitas, K-A-R-A-V-I-D-A-S. It's a significant. You do a Google search for Caravitas, you'll find it right away.
Pam, we have one more question.
One more quick one. And that is, periodically a judge will require a cause for a motion to withdraw, 13th Amendment notwithstanding. Am I permitted to disclose that I am required to withdraw due to a fraud by my client?
Ooh. No opinion, Justice?
Don't know, yeah. It's dicey. I don't have an opinion.
Jim?
Then we go to 3.3. Don't do anything unless you've counseled with counsel about the appropriate matter to seek withdrawal. It may be appropriate for you to seek a withdrawal that is quote-unquote noisy, but there's an art to doing the noisy withdrawal in an appropriate way because you still have to minimize damage to the client, even though you don't like the client's put you in a box.
There you go. Well, on that note, I want to thank Justice Maureen Connors, Jim Grogan, Sara Parikh, and all of you here today for a wonderful discussion, and I hope it's moved the ball and the needle forward for us all. You've spent so much time. You're incredible. Thank you.
Well done.
Thank everyone for coming. On behalf of all of us at Clifford Law Offices, we would like to thank you for attending today's program, The Ethics of Client Communications. Please be sure to fill out and submit the evaluation form. It can be found by clicking on the evaluation tab. The evaluation certificates are also at your seats here. Certificates of attendance will be submitted by email to you within the next few days. All of you attending in person here at DePaul, please be sure to pick up your certificate of attendance at the check-in desk. Also, please remember, if you would like to order the book by Professor Stephen Salzberg, Trying Cases to Win, click on the link next to the video. Thank you again for attending. Good night.